Well, Elizabeth, shall we start?
Let's do so, Barbara.
Yeah.
Yes.
Yes. Well, good morning, everybody, to our Land Chambers training session on committals under the new, or perhaps I should say newish rules under CPR 81, because as I'm sure all of you are aware that these new rules under the changed Civil Procedural 81 have been in force for some nearly 6 months now. But I thought this would be a very good moment to go through the rules, remind you of things that need to be complied with when making contempt applications, and also we wanted you to look out for some of the pitfalls when making contempt applications. Well, you have already seen us on the screen. You've seen my colleague Elizabeth on the screen, and indeed you've seen me with in that photograph a rather better haircut, it has to be said. And that is what we are proposing to do today by way of outline. What I would like to you to do is to keep your cameras off at all time. This is just to avoid bandwidth problems, certainly right to the end, and we would also like you to stay on mute until the question and answer session at the end of the 90-minute session today. So fear not, you will be able to contribute, and of course, if we were having an in-person seminar, I would actively encourage you to interrupt us and ask when you have questions, but because this is a virtual seminar, I think it's much better if you wait with your questions until right to the end of the seminar. So what we want to do today is give you a sort of general overview of CPR 81, and then we're going to look in more detail at individual rules, and then we want to think with you about when to make a contempt application, and perhaps also when not to make a contempt application. And then we want to look with you at the nitty-gritty of making a contempt application. And so, but another thing perhaps to emphasize is that we're going to be looking at the civil procedure rules today, mostly in the context of antisocial behavior. We simply don't have time to touch on contempt proceedings in the context of, for example, false statements in witness statements having been made. So we're focusing specifically on matters which will be of, as local authority lawyers, will be of immediate interest to you, which is antisocial behavior, but perhaps also I'm going to, at some point, I'm hoping to mention gas injunctions as well, but we're not going to roam across the entire spectrum of contempt proceedings. So at that point, I'm going to hand over to my colleague Elizabeth Duomo, who is going to give you an overview of the new regime.
Thank you, Barbara. Well, welcome everybody. As Barbara outlined, on the 1st of October 2020, so relatively new rules, a new streamlined procedure for contempt applications came into force under the new CPR Part 81. I'm going to talk a little bit about the origins of the new CPR. Well, CPR 81 and its accompanying practice direction was first introduced in 2012 by virtue of the Civil Procedure Amendment number 2 rules. Its aim was to provide a complete body of rules governing contempt proceedings, both in the High Court and in the County Court. In 2014, the old CPR Part 81 was amended. The amendments provided for different categories of contempt, and this is the one that was immediately replaced. The old CPR 81 comprised of 38 rules, 2 practice directions, and a practice guidance from the Lord Chief Justice. To say that it was unwieldy and had become somewhat cumbersome, I think, is an understatement. It had become the subject of much judicial criticism because it was deemed to lack consistency. For example, where there was an alleged contempt, it could fall within multiple categories, and not all categories require the court's permission before a then committal application could be made. So if you just bear with me, there's a slight time lag sometimes in the moving of the slides. Okay. So the new Part 81 was the product of a consultation exercise undertaken by the Civil Procedure Rules Committee. It was undertaken between March and May 2020, so it was actually quite a swift consultation. Barbara is going to take you through the new Part 81 step by step in the next segment of this seminar. But for now, I think it suffices to say that the Civil Procedure Rules Committee managed to simplify contempt proceedings by reducing what was 27 rules into 10 distinct rules. The practice direction under the old Part 81 was also revoked and hasn't been replaced. The simplification of the rules was achieved in, I think, 2 ways. Firstly, by removing the subdivision of the rules based on the different types of contempt and the jurisdiction that they fell under. And then secondly, by discarding the rules that attempted to codify the various utilities of the substantive law of contempt. The result of the changes made to the new CPR Part 81 has, I think, in theory, made the process of opposing a contempt application far more straightforward, and especially so for an unrepresented defendant. So the main changes heralded by the new Part 81, I think, can be grouped into 5 distinct headings. Those are terminology, simplification of the procedure, the court's ability to initiate contempt proceedings, material amendments to other parts of the civil procedure rules, and the introduction of new procedural forms. There has been a real, I think, concerted effort to demystify the terminology around contempt proceedings. So you'll find in the new rules a greater use of plain English wherever possible. Barbara will touch upon this further in the seminar, but for now, examples are, for example, changes of how the parties are referred to. So you're no longer known as applicant and respondent, but referred to simply as claimant and defendant. There's also been, as I mentioned, a simplified procedure. There has been a real roots and branch clear out of the old procedural rules. The rules used to depend on jurisdiction and the nature of the contempt alleged. The new CPR 81.3 now clearly identifies various procedural routes for making a contempt application and the level of judge required to determine such an application. In particular, Civil Procedure Rules 81.35 also prescribes two circumstances when the court's permission is required to make a contempt application. Firstly, when there's been an interference with the due administration of justice, except in relation to existing High Court or County Court proceedings. Secondly, where there's been an allegation of knowingly making a false statement in an affidavit, affirmation or other documents verified by a statement of truth or in a disclosure statement. This second category, I think, accords with the changes that were made to statements of truth, which you'll be aware of, which came into effect from the 6th of April 2020, that required makers of statements to certify that the making of a false statement in such a document was a contempt of court. CPR 81.4 has also brought under the rules a single requirement for contempt applications. The Civil Procedure Rules Committee, I think, in its consultation paper on the rules change, described the new CPR 81.4 as the cornerstone, actually, of the new rules. It simply sets out the factual and procedural safeguards that must be addressed in a contempt application, and to enable its disposal in a manner that aligns with the overriding objective. And that really is just to dispose of matters justly, fairly, and at a proportionate cost. I referred earlier to the ability of the court to initiate its own contempt proceedings. Under the old rules, if you'll remember, the court could only do so or initiate a committal application in exceptional circumstances, for example, where there'd been a contempt in the face of the court. And that was under, I think it was CPR 81.16. In all other cases, there had to be a referral to the Attorney General to determine whether a prosecution should be brought. The new CPR 81.61 specifically provides that if the court considers that there has been a contempt of court, including a contempt in the face of the court, it can decide whether it should initiate of its own volition proceedings against defendant. Those would be contempt proceedings. In terms of the material amendments to other parts of the civil procedure rules, well, I think two noteworthy ones, and I've already mentioned one, would be, first of all, that the proceedings for contempt may now be brought against a person who makes or causes to be made a false statement, as I outlined earlier, and that's CPR 32.14. So now you have documents that are prepared in anticipation of proceedings are verified by a statement of truth, and there's that declaration that there's an honest belief in the truth of that document, and if it's a false statement has been made, then that can lead to contempt proceedings. The second one is CPR 31.23, which provides that proceedings for contempt of court may be brought against any person if he makes or causes to be made a false disclosure statement without an honest belief in its truth. The last point that I'll touch on, and Barbara will speak to this further in the seminar, is that the new CPR Part 81 has also required the introduction of new court forms, but these will be discussed later. But it suffices to say for now that it has effectively replaced 27 prescribed forms into just a simplified 4 new forms. I'll hand over to Barbara in relation to a step-by-step guide to the new Part 81.
Right. So now that you've had the overview, now that you know what the aims of new CPR 81 are, let us look at the individual rules in more detail. And perhaps one thing to highlight immediately, these are procedural rules only. What you read in CPR 81 is not the whole law relating to contempt proceedings, because these rules, and of course that also applied to the previous, the old rules under CPR, they don't actually affect or modify the substantive law of contempt, which, as I've indicated on the slide, is a mixture of statute and the common law. And of course, some of these, especially when we think about later on in the seminar about procedural safeguards for the defendant, and not just procedural safeguards, but safeguards generally for the defendant. That's where the obviously the common law and the legislation comes in quite a bit. One thing that's really completely new compared to the old regime is that, and Elizabeth has already highlighted that, there is no practice direction. Everything is contained in these 10 rules that we're about to look at in more detail. And it is actually, in terms of a set of rules under the civil procedure rules, it is, I wouldn't say it is a massively short part under the civil procedure rules, but it is not the longest part under the civil procedure rules either. And some of you in this virtual room may be still involved with committal proceedings that started pre-1st of October 2020. And it's important to know that there were, with some tiny exceptions that I'm not going to go into now, there weren't any transitory provisions. So that means is that as soon as the new rules came in the autumn of last year, proceedings that were already in existence then continued under the new rules that we're about to look at. So in the next two slides, and this and the next slide, I've simply given you the titles of the individual rules under CPR 81. Now, I don't want to go in minute detail through every single of these 10 rules. There are some that I want to highlight more than others. One of the rules I want to highlight in particular, and that's going to be in part 5 of the seminar. It's the requirements of a contempt application, because there are really quite a lot of steps to comply with when it comes to making a contempt application. And then this is the second of these slides, giving you rules 81.6 to 81.10. Perhaps the things the rules to be particularly aware of is actually what happens during hearings, and that's CPR 81.8, sorry, and the powers of the court under 81.9. And so homing in a little bit more on the individual rules, the scope as set out in CPR 81.1 emphasizes or makes it very clear that these are procedural rules, and CPR 81 has effect, subject, and to the extent that it's consistent with the substantive law of contempt of court. And then 81.2 is the interpretation, and it's in that part of Rule 81 that the new terminology is introduced. Elizabeth has already highlighted as an example the change from applicant to respondent to claimant and defendant. And you may already have noticed that it is no longer called a committal application. It is, the new terminology is a contempt application. Whether that language makes the contempt procedure so much more accessible, I'm not so sure, and I think we can be certain that probably the use of the word committal will survive for a very long time. And indeed, when I went through the slides yesterday, I noticed that I had used the word committal rather a lot in my slides, so I actually substituted the word contempt quite frequently when I revised the slides yesterday. And CPR 81.3, the essence of this is that it clarifies so this sets out how to make a contempt application, and it clarifies the procedural rules involved and the level of the judge required. And it's as regards the level of the judge required, we will shortly be looking at 2 slides, because when these rules came in the autumn of last year, there were at the start there were some glitches regarding the level of the judge required. Perhaps another issue to highlight in relation to CPR 81.3 is that it sets out that in existing proceedings, which is, I think, what we are talking about today, specifically in the context of antisocial behaviour, is a contempt application is made by using the provisions of CPR Part 2023. And then if it's otherwise than in existing proceedings, CPR 81.3 makes it clear, then you use the Part 8 procedure. Now, we did have, I've already touched on that a few seconds ago. There was in the autumn there was a glitch, or shall we say a fly in the ointment. There was a jurisdictional issue that arose because the rules under the provisions under CPR 81.3 were interpreted that contempt applications could only be heard by circuit judges, and that the jurisdiction of the existing jurisdiction of district judges to hear contempt applications under CPR 2, that jurisdiction had been removed. And I do remember actually being in Bromley County Court on a contempt application in, I think it was actually the first half of October, and I do recall very vividly, and indeed I think it was myself who raised the jurisdictional issue. I do recall very vividly that the district judge made a frantic telephone call to a circuit judge at Central London to explore this issue. And as you can see in the slide I've just put on the screen, it was very quickly resolved, and there is now a clarification which provides that district judges can hear a contempt application where a rule or a practice direction permits that, and under and it is antisocial behaviour applications are one of those applications that in relation to which a district judge has the jurisdiction to hear a contempt application. It may be, I mean, I suspected this has now been very widely ironed out, but just in case it still comes up in a county court before a district judge, you are now on firm ground to say to the district judge that he or she has the jurisdiction to hear a contempt application in the context of antisocial behaviour proceedings. What I've put up on the slide is something that probably is not going to concern us very much in the context of antisocial behaviour contempt proceedings. What CPR 81.3 also makes clear is that there are certain circumstances where permission to make a contempt application is required, but they don't concern us in the context of antisocial behaviour proceedings. They are interference with the due administration of justice and an allegation of knowingly making a false statement. But obviously, as I've already highlighted right at the start of our seminar, that is not something with which we are particularly concerned with today. Now, CPR 81.4 is something that really, I think, for all of us in this virtual seminar is a very, very important rule. And whenever, for example, I'm instructed to deal with contempt proceedings, one of the first things I do when I receive the papers is to double check whether the requirements set out in great detail under 81.4 have been complied with. And it's for that reason that we will come back, Elizabeth and I will come back to this very, for practical reasons, but also for procedural reasons, a very, very important rule. We will come back to that in more detail in the in a later part of the seminar. 81.5 is a rule which provides that, and you're very familiar with this already from contempt proceedings under the old regime, makes it clear that a contempt application needs to be served personally. There are some exceptions built into the rule 81.5, which is in certain circumstances there may be, it is permissible to serve on a legal representative instead of effecting personal service. But the default rule is that it is a personal service, and it's quite important to look at the specific wording of 81.51. This is unless the court directs otherwise in accordance with Part 6, which is the service provisions under the civil procedure rules, and except as provided in paragraph 2. That's the rules relating to service on a legal representative. The application and of course all the evidence in support must be served personally, and then just to highlight the rule under 81.52. It's possible to serve on the legal representative unless, to quote you the wording, the representative objects in writing within 7 days of the receipt of the application. Now, all of us in this virtual seminar will be aware of problems with personal service that that can arise in the context, obviously not just of committal or with contempt applications, but we will all have needed to deal with these issues. And what I found quite interesting is something you may want to have a look at, is a reference in the gloss to CPR 81.5, which deals with the very limited circumstances where perhaps it might be, and this is disregarding now service on a legal representative, where it might be possible to dispense with personal service. And I've quoted you in this slide here a verbatim quote of a circumstance where personal service is likely to be dispensed with, namely in circumstances where the court is satisfied that the defendant is deliberately taking steps to evade service, or where they have full knowledge of the contempt proceedings. And Elizabeth has already mentioned the 2020 consultation about reform of CPR 81, and it's quite clear from the quote that I've put up on the screen that this is likely to be a very limited exception. And I recall being at I think it was last month, I was in Willesden County Court dealing with committal proceedings in relation to non-compliance with a gas injunction, and in that case, the very wily defendant who was aware that a contempt application was about to be made, because we had already served the application on that defendant in the post as a sort of informative step, had then taped shut the letterbox to a defendant's property, and had put on a big notice on the front door of the property saying that this was just outrageous, that we would deem to want to take steps for a contempt proceedings, and then subsequently the door wasn't opened, and personal service, which we did try to effect, was not possible. And in those circumstances, the judge, where it was quite clear from the evidence that we had put before the judge, this was a deliberate attempt to evade service. That was one of the, so in that case, we actually got permission to serve, I think it was by, if I remember rightly, by affixing the application to the door of the property. But it is a very limited exception. 81.6 is not something that I propose to spend a great deal of time on, because that doesn't concern us so much in the context of antisocial behaviour. It's the court can initiate a contempt proceedings itself. 81.7 contains the various directions which the court can make or will make for contempt proceedings. And something that's actually quite interesting to note, you will recall from the pre-October CPR 81, is that there was a requirement that the matter would generally be heard not less than 14 days after service of the contempt application, and that time requirement is actually not replicated in the new CPR 81. But I suspect there will be a drive to dispose with these applications as speedily as possible. 81.8 sets out the manner in which contempt proceedings are to be heard. Of course, they're going to be public. And 81.8 is an example where previous practice directions have been incorporated into the civil procedurals in relation to the conduct of these proceedings. 81.9, I've already mentioned it, I believe, earlier, sets out the powers of the court in contempt proceedings. Now, the three last bullet points I've put on the slide, they are actually, and I need to emphasize that, they're not in the rules. This is just a reminder of what the powers of the court in these contempt proceedings are. It could make no order, it could impose a fine, or it could impose imprisonment of up to 2 years as set out in a statutory provision, namely Section 14 of the Contempt of Court Act 1981. And then finally, the last provision of those 10 rules is the possibility given to the defendant to apply to discharge the contempt order. So that was homing in on CPR 81 in a bit more detail, and I will now hand over again to Elizabeth for when to make a contempt application.
Thanks very much, Barbara. Well, a breach, really, I'm going to focus in this section of the seminar on breaches of antisocial behaviour injunctions in particular. And in relation to that type of breach of an injunction, an individual can be brought before the court in 3 different ways. First, upon the arrest by the police, if there has been a breach of an antisocial behavioural injunction where a power of arrest has been attached. And that individual then can be pursued under CPR 65.47. The second scenario is where there's been an application made for an arrest warrant, and that's made pursuant to Section 10 of the Antisocial Behaviour, Crime and Policing Act 2014. And the matter is again being pursued under CPR 65.47. The last scenario, and the scenario really envisaged by CPR Part 81, is upon a contempt application being made where an application notice is issued under CPR Part 23. And in that scenario, a court, there is no request made to the court for an arrest warrant to be issued. This is made in accordance with CPR 81.31. I think it's worthwhile reflecting on that, because I often find that even in circumstances where there has been a breach, for example, of a power of arrest and the individual has been brought to or brought before the court in relation to that breach, sometimes you find judges still ask whether there's going to be a separate contempt application made, but there is no need for that separate application to be made. CPR 65.47 allows the defendant to be proceeded against under what is effectively contempt proceedings without a separate application being made under 81.31.
Good morning, Anthony.
It comes you up,
So a contempt application carries very serious consequences for an individual who is found to be in breach.
Yeah.
At the most serious end of the scale, it can result in an individual being deprived of their liberty. Any alleged breach of an antisocial behaviour injunction in contempt proceedings must always be proved to the criminal standard, and that's clearly beyond a reasonable doubt. Bearing this in mind, I think three factors should be considered before a claimant decides to make a contempt application. First one is, has there been a fulfilment of the initial procedural safeguards? Secondly, there should be a consideration of the seriousness of the breach. And lastly, the strength of the evidence. So taking each of those in turn. It's always worth asking, has the initial procedural safeguards been met when making a contempt application on the basis of an antisocial behaviour injunction? So it's prudent to ensure that, and Barbara has already touched on some of these, that some of these key safeguards have been met. The first one I would definitely recommend is that ensuring that the actual injunction order carries on its face a penal notice. And that really just sets out clearly to the defendant that if there is a breach, that they do face the threat of contempt proceedings being brought against them. Secondly, there should always be a safeguarding in terms of service of the antisocial behaviour injunction. It should be clear that personal service, where it has been affected, has been made, and that a statement of service has also been obtained, and that this can be evidenced very clearly. And I think Barbara has already touched on this, or will touch on it later on, that when you're making your committal application, that it's easy to refer back to that statement just to satisfy the court that personal service has been affected, or where personal service was dispensed with by the court, that order too has also been exhibited and referred to when the contempt application is being made. Also, I think, thankfully, I've never come across an instance where this hasn't been done, but it's always worth ensuring that a copy of the antisocial behaviour injunction, where a power of arrest has been added, has been deposited at the police station where the alleged conduct of the defendant has taken place. And of course, it should always be remembered that such a provision should only be complied with once the defendant themselves has been served with a copy of the injunction and power of arrest in circumstances where both were obtained without notice. So once those key procedural safeguards have been met, I think the next thing that you have to consider really is, as my next slide highlights, bear with me. What happens if they haven't been met? In that scenario, under the old rules, the practice direction provided a safeguard whereby the court retained discretion to simply dispense, to remedy a defect in terms of the procedural, in terms of any kind of procedural error. However, as Barbara mentioned, the practice direction has been revoked and has not been replaced. However, in the case of Deutsche Bank Attorney General and Sebastian Holdings, Inc. and another, the High Court reaffirmed that the power to waive any kind of procedural defect had been retained, even though this hasn't been set out in any additional practice direction or actually incorporated into the substantive rules themselves. So it's worth remembering, yes, it's important to get it right first and foremost, but there is this fallback provision whereby the court could dispense with any error made. So moving on then to considerations of seriousness of the breach. I think careful consideration should always be given as to whether a breach of a term of an antisocial behaviour injunction necessitates a contempt application being made immediately. And I stress that word immediately. Of course, antisocial behaviour, there is always a spectrum of conduct that one looks at. And that could be anything from intermittent low-level nuisance to the upper end of the scale where there is physical harm. I had one case where the defendant had actually burnt down the accommodation in which he lived in, and he was known for causing fires. So he was a known arsonist. And one of the provisions of the injunction that was obtained was to prevent this type of behaviour. And of course, if there is any attempt to do that, that contempt application should be brought immediately, because that's a sufficiently serious breach to warrant such a contempt application being made. So as I've highlighted, if there is serious conduct where there is a risk of harm to somebody, then there should be no hesitation in pursuing a contempt application. But where there has been a single breach of antisocial behaviour injunction dealing with low-level nuisance, and when I say low-level nuisance, I use again the example of noise nuisance. Of course, there is a spectrum of nuisance even on that scale, but where it's relatively low level, I don't think it's always advisable to seek to bring contempt proceedings for a single breach. It's worthwhile writing a letter to the individual, drawing to their attention the terms of the injunction and setting out that if there are subsequent breaches, there is the real possibility that contempt application will be made. Lastly, it's always worthwhile considering the strength of the evidence against a defendant in these circumstances. any allegation of breach will need to be proved to the criminal standard beyond a reasonable doubt. If the evidence as to whether the defendant has committed a breach is unlikely to meet the criminal standard of proof, then it's highly unlikely that an application for contempt will succeed. So, for an example, an injunction was obtained against a neighbour, let's call the neighbour X, for threatening and intimidating conduct against neighbour Y. Neighbour Y alleges that he received a threatening note through his letterbox, but it's unable to show beyond any reasonable doubt that it was sent by neighbour X. Careful consideration will need to be given as to whether neighbour Y's belief alone will be sufficient to meet the criminal standard of proof if there hasn't been further investigation of whether fingerprinting or anything else like that. So before a contempt application is pursued, a claimant should always objectively assess the strength of the evidence that they have in relation to each alleged breach to determine if it will discharge the evidential burden of proof to the criminal standard. And that's something that should always be remembered, and I can't stress that enough. I'm now going to hand over to Barbara, who's going to discuss how to make a contempt application, and I will jump in also in relation to this. Barbara.
Okay, I think I'm now unmuted. Yeah, thank you, Elizabeth. Before I launch into number 5, can I just request that there is a gentleman in our group who hasn't muted himself, and I can sometimes hear him probably speak to a colleague. So I just wondered whether it would be possible for that gentleman to mute himself. I apologize. I have there's some police sirens in the area where I live, so you may hear them on the when I speak. I mean, they're there sporadically, so I apologize for that interference, but I can't do anything about that. So part 5 is about the formalities of making a contempt application, and the requirements that you have to meet. And I think it's really important that you are all very familiar with all the steps that you are required to follow pursuant to CPR 81.5, because it is very clear that the rule makes it very clear that these are mandatory steps. And of course, if you slip up and don't follow the mandatory steps, that may well be the end of your committal application. In a way, CPR 81.4 is very useful because it had no equivalent in the pre-October CPR 81, but now there is actually a kind of noddy guide how to make how to comply with the procedural requirements and the formalities of making a contempt application. Now, the requirements, the steps that you have to fulfill are, of course, matters that weren't just invented in 2020 during the consultation process. The requirements contained in that rule were developed in case law pre the changes, and of course there is a very important function for these. The very important reason for these requirements is because they are designed to ensure procedural fairness to the defendant, bearing in mind in particular the serious consequences or potentially very serious consequences of a committal application. So 81.4 is all about safeguards for in respect of a defendant. And I think it is at this point that I hand over to Elizabeth, because Elizabeth wants to speak in this joint session, wants to mention to you in more detail the procedural safeguards. Elizabeth.
Thank you very much, Barbara. As Barbara has already underscored, the new CPR 81.4 has these inbuilt procedural safeguards for the defendant, and they are essentially codified requirements for the making of a contempt application. I've picked a number of these because for me, I think they are extremely important safeguards for the defendant. Before, under the old rules, when making committal applications, a greater emphasis was placed on the judge to highlight these procedural safeguards and to make a distinct point of mentioning it to the defendant. However, the new CPR 81.4 has shifted the responsibility for this very much back onto the claimant rather than the judge. So, of particular note are the following statements that must be included in the contempt application for the benefit of the defendant pursuant to CPR 81.421 right through to 81.42N. The first and foremost is that the defendant has the right to be legally represented in contempt proceedings. This, I think, is really important because the nature of these proceedings are criminal, and because of that there is the risk that obviously that the defendant will be deprived of their liberty. Before, there was some confusion as to actually whether a defendant or matters could be adjourned to give the defendant time to obtain legal advice. Well, that has clearly been set out in the rules, in that the defendant is entitled to a reasonable opportunity to obtain legal representation and to apply for legal aid, which may be available without means test. And this has to be notified to the defendant as set out by CPR 81.42J. And I think that requirement to be told that they're entitled to legal aid is important, because I think most judges obviously now are very much aware that criminal legal aid in these types of contempt applications are available. Previously, some judges were unaware of that fact, but it clearly is, and time should always be given to the defendant to source legal representation, to obtain advice from the solicitor, and to make an application for legal aid. The fact that it may slow down the proceedings themselves is neither here nor there. That procedural safeguard is important. The defendant may not have English as their first language. Well, in those circumstances, they may be entitled to the service of an interpreter, and this also should be notified to them as required by CPR 81.42K. The following three procedural requirements that I would like to highlight are that the defendant is entitled to a reasonable time to prepare for the hearing. Obviously, how long is a piece of string in terms of what is a reasonable period of time? But the fact that a hearing has been listed and the defendant informs you in advance that, look, there's been a hold up in the making of the legal aid application, but I am going to make the application, or I'm just waiting for the determination of my application, I think would necessitate an adjournment being agreed to in those circumstances. And it's more than likely that a judge would take a very dim view if the claimant tried to proceed with a contempt application, knowing full well that the defendant hadn't been given the opportunity to ascertain or to obtain legal advice and have their legal aid certificate sorted. So yeah, a reasonable time should be given for preparation. It should also be stressed that the defendant is entitled but not obliged to give written oral evidence in their defence. This is something that previously the judge would stress, and I think judges will still stress that fact to the defendant, but there is now an onus on the claimant to also draw that to the attention of the defendant. And the last matter, which is somewhat tied in with the earlier one, is that the defendant has the right to remain silent. And that's because obviously in criminal proceedings, there is a right not to incriminate yourself. And so that should also be stressed to the defendant when making a committal application. I'm going to hand back to Barbara, who's going to take you through, I think, some of the forms.
Right. So at this point, well, I'm already talking about other forms, but I actually want to take you through. Yes, sorry, I skipped a slide. Form N600, and I'm just about to show you, or at least try to show you, on the screen Form N600. That is really, and I suspect a lot of you will be familiar already with Form N600, but I would still say it's required reading to put on your bedside table, so that you really familiarize yourselves with all the matters that Form N600 requires you to mention when making a committal application. Form N600 is actually quite a useful form to have, because it contains that very long list of requirements and formalities set out in subsections A to S under CPR 81.4, including, and I stress including, that's not the only requirements here, the nature of the contempt, the date and time the order was breached, confirmation that the order breached contained a penal notice, and among the requirements, a brief summary of the facts said to constitute the contempt. Now, I think inevitably it will be very labour intensive to complete Form N600, because there's a lot of information that you have to put into the form. So I would suggest don't rush completing Form N600. Now, at this point, I said I wanted to show you Form N600, so I'm just going to remove the PowerPoint presentation and call up Form N600, hoping that this is not the moment in the seminar when everything goes very badly wrong. So bear with me a moment while I call up another form. So here, I hope you can all see it. Famous sorry, I think I've muted myself for some reason. Let me just repeat what I said. So here is form N600, required reading for you. And as you can see, it is actually a rather lengthy form, 10 pages long. And here you even on already on page 1, you get a sense of the enormous detail that is required to complete the form. But of course, don't just focus on the boxes that you need to fill in, but also the very sort of important reminders of the form as to what you have to do. The written evidence in the form of an affidavit obviously has to be attached to that form. And then, and Elizabeth has already touched on this, it's a part of the form that addresses the defendant and tells the defendant the potential consequences of a successful committal application, and then this list of rights as a reminder to the defendant of what her or his rights are. And of course, in a way that makes it easier for you, so you don't actually have to set out these rights and entitlements, but that's also, I think that list is also a reminder of these rules, really trying to ensure that they are the appropriate safeguards for the defendant. Of course, box number 5 is a very important part of the form, and I would suggest when setting out the nature of the contempt, when setting out the examples, I think again, and I'm sure you will be aware from old committal applications having perhaps been criticised by a judge that these allegations are a little bit superficial and vague. I think it's very important to spend time on setting out carefully and in sufficient detail the nature of the breaches. And again, just as a reminder, box number 7, don't forget to insert the dates and terms of the order or indeed orders breach. So again, yet another reminder of the level of detail required, information required in relation to service. And as you can see, we're only on page 5 of this form, so we're halfway through the form. So and again, in terms of this is the section 11, and this actually relates to a breach of an undertaking as a kind of sort of subcategory of contempt proceedings. Again, boxes 11 and box 11 really requires you to consider whether there is understanding on the part of the defendant in relation to any breaches. And again, number 12, box number 12 highlights once more this is the summary of the facts alleged to constitute a contempt. You can see the size of the box. You are required to go about completing these forms in considerable detail and with great care. So at that point, I will try and go back, and I hope, and obviously don't forget to pay the court fee of £255. I will try and go back. Hopefully that will work. Go back to the PowerPoint presentation. Yes, here we are. And then as a reminder, Form 600 is only one of the forms that you need to be aware of. I think it's probably the most important form for our purposes. And of course, as Elizabeth said in her overview of CPR 81, there was an introduction of other new forms, and I've set out the nature of those forms N601 to N604, so that you are aware of those screens, of those forms set out on the screen as well. Again, I think we've already touched on CPR 81.5, the requirement of personal service, but we thought we'll put a slide about personal service in again once more, just to remind you of the importance of this. I'm not sure, Elizabeth, whether you wanted to say anything else about personal service at this stage. So I think I'll just hand over to you.
Thank you, Barbara. I think it's just to reinforce that message that you gave earlier, that it should be personal service. That should be the default position. Again, this is a procedural safeguard for the defendant, because obviously of the serious nature of these proceedings, they need to know about it. But as Barbara has already mentioned, there are instances where a defendant is knowingly trying to evade service, and therefore, if that's the case, then there should be an application made for substituted alternative service. But in any event, the default position should always be personal service on the defendant, or if they have legal representatives, service on the legal representative, unless they write and notify the court within 7 days of receipt of the contempt application that they are not either representing the individual or not on record as representing the individual defendant. But there is something that I wanted just to quickly jump back and touch on in terms of Form N600 that Barbara referred to, and that was the issue as to just confirming whether the defendant understood the terms of the injunction that they were breaching. I think that ongoing duty to assess whether the defendant has capacity to understand the terms of the injunction against them cannot be underestimated, because obviously if there is any suspicion that throughout any time that the injunction is enforced, that the defendant either has lost capacity or there's something that's given the claimant rise to think that the defendant no longer is able to knowingly comply, then that should be brought to the court's attention, and it shouldn't be a question of waiting for a contempt application to be made for the court to be made aware of that. And I think that's also an ongoing Equality Act duty in that regard. And so I thought that was a very important point that Barbara touched upon, that I just wanted to go back and underscore.
Yeah,
Barbara.
And just to stay with that point, I mean, points relating to capacity and duties under the Equality Act, specifically Section 149. I think it's very clear from Form N600, and of course, I think also the whole thrust of CPR 81 is that there is an onus on the claimant to ensure that all of the procedural safeguards in relation to the defendant are complied with, and there's very much an onus on the claimant to put all its cards on the table in terms of as regards all the information that needs to be put into the committal application and needs to be put before the court. Right, I can see it is 11:18, and that is just perfect timing, because that gives us some 10 minutes for questions and answers. So it's now over to you, and I think it's probably, if you want to, if you haven't gone to sleep yet after this perhaps quite technical talk about CPR 81, perhaps this is an appropriate moment for you to turn your cameras on, or certainly unmute yourselves, and ask some questions which we'll try our best to answer. So over to you.
Hi, Barbara. May I ask a question?
Hello, Fabian. Good morning. Yeah.
Morning. So I've never done a contempt application before. So I just wanted to find out what practically happens in terms of if, for instance, we have an injunction, we obtain an injunction order with a power of arrest, say, for example, due to nuisance by the defendants, noise nuisance, for example, and over the weekend, the neighbours played loud music or started banging on his ceiling against his neighbour's ceiling. The neighbour calls the police, and would the police, if the police arrested him, would they then bring him to court on the following Monday? Or how does it work practically in terms of what they do, the police, in terms of taking the case to court?
Elizabeth is nodding, I'm nodding. I'll let Elizabeth answer, and then I may chip in as
Thanks very much.
Yes.
Thank you, Barbara. Hi, Fabian. Well,
Hello.
You're absolutely right in those circumstances. If that term, the noise, the playing music at a loud volume, was a term to which a power of arrest attached, then the police could, within the prescribed time 65.47, produce that person to court the following working day, so that would be the Monday. And the court would then determine whether they were going to proceed against the individual. But the court would always demand that the police notify you in those circumstances. But the option, I think, it's worthwhile remembering that the decision to proceed would also be yours. The mere fact that they've been brought before the court doesn't necessarily mean that you have to proceed in respect of that single breach alone. You can simply indicate to the court that you would be content for the court to issue a warning. So it's again making that considered decision as to whether for this single breach it's worthwhile making a contempt application. Okay, hopefully that helps. I'll jump back to Barbara to let her.
Yeah. But what I think I'm speaking just from say breaches of a power of arrest or breaches of an injunction with a power of arrest that I've been involved in. I mean, in my experience, very often, I think by the time the police arrest a defendant and the defendant is produced at court, probably in the, sort of broadly speaking, there have already been perhaps several breaches, and then eventually the police got involved and arrested. So again, as Elizabeth said, of course, it is very much your judgment call. I think perhaps generally speaking, and this is really, I stress very much, generally speaking, if it's the first incident of a breach involving noise nuisance, generally speaking, perhaps a warning letter might be more appropriate. However, if it's really egregious incident, like, a party going on all night, I mean, perhaps then a one-off incident is so egregious that actually it might be justified to go for contempt proceedings because of the nature of the breach. But I think it's very much a judgment call, and I think generally speaking, perhaps as a local authority, yes, you do need to think about the interests of the neighbours, but at the same time, I don't think you want to come across as being sort of oppressive and heavy-handed either. So I think it's much a judgment call.
Okay, that makes sense. Yeah. Okay, thank you, Barbara.
Not at all. Any experiences you want to share with us about the new regime? Because obviously the new regime has been in place now for some 6 months. Any issues, any problems you've experienced that
Any observations?
Yeah, or observations, yes.
Right, can I ask just a quick question? It's Glenn Craig here from Northern Forest. I'm afraid I'm not showing myself because I hadn't anticipated, and my backdrop is less desirable to see. So I'll leave the video off if you don't mind.
Yeah.
So the question is, this common question I actually get asked is about the practicalities of getting an affidavit sworn, especially at the moment because of courts being closed, so the police can't go into the court office to get it sworn. So are there any practical ways around that, and how forbearing are the courts being?
In my experience, yes, that's certainly been very much an issue over the last, well, I mean, really now last year or so. I have done cases where the court has ordered that a witness statement could be produced instead of an affidavit because of the specific difficulties in producing an affidavit in circumstances where there are restrictions on contact. But I think generally the expectation is, even in the in current circumstances, if at all possible, produce an affidavit, and then a witness statement is the sort of default position. I don't know, Elizabeth, whether that's your experience as well.
Yes, it is, Barbara. I mean, I find that actually judges don't tend to criticise if a witness statement is produced. I mean, given the nature of the proceedings, they prefer an affidavit, but they don't necessarily give you a slap on the wrist if a witness statement is produced instead.
But I think there probably should always, perhaps in the witness statement, if it has really been impossible to get the affidavit sworn, perhaps a reference to the difficulties that you've experienced. So to make it quite clear that you just haven't produced a witness statement because that was so much easier. I think you should sort of outline the efforts that you have made. Does that deal with your question?
Certainly helps. I mean, the options that we've been using at the moment are just to ask, for example, the police to go to a local firm of solicitors, but then they have to pay a little bit to get a swear done. So that's the only option, other than going to court with an unsigned affidavit and getting it signed there and then on the morning. Are either of those effective? They seem to work for us. So.
Sorry, Glenn. Yeah, if you're able to get the affidavit signed on the day, I think there's no problem with that at all, actually. Yeah. And I think judges are quite used to that happening. That's definitely a good workaround.
Yeah, I agree with that. Yes, I think try and be as practical as you possibly can be.
Yeah, lovely. That's great. Thank you very much.
Thank you. Barbara, I can see that we've got a question from Balji Verdi. I'll just read that out for everybody's benefit. Yeah. We've had a couple of committal applications, but so far we have found that county court judges do not seem fully aware of their powers and generally reluctant to deal with the matter where a defendant's been arrested and brought before the court the next day. Have you got any tips on how to address the court's concerns? Barbara, do you want to take that, or and I'll jump in?
Yeah, I'll
after?
start with it, and then you can take over. So I'm interested to hear that these concerns about jurisdiction still, which I assume is the thrust of the question, still haven't quite come through, trickle down to district judge level. I would simply refer them to the clarification provided in relation to 81.3 and remind them that they have got the power to deal with this matter under the new regime. Elizabeth, what you wanted to add to that?
Just in relation to that, Baljeet, I think it's correct. I think when a defendant is brought before the court because there's been a breach of a term of a power of arrest, I think when it's commenced that way, it tends to throw judges, because there is a question as to whether the application is a traditional committal application or contempt application brought under CPR Part 81, or whether it's a procedure that 65.47 requires to be followed. And I think actually the reality is it's 65.47 that takes precedence in that scenario, because it is the police that are producing the individual. But my top tip is just to refer the court back actually to what CPR 65.47 states. And it's very clear step-by-step guide as to what the court's powers are in those circumstances. Sometimes, and I think I touched upon this, the court still asks a local authority or a housing association if they wish to proceed also via a contempt application. But there's no requirement to do that. That's just a real belts and braces measure. But that would be my tip. Refer the court back to what 65.47 states, which is essentially that the court has a set period of time in which to deal with an application, to deal with a contempt where it's been the police that's brought the matter or brought the defendant to court. And some judges try and bat it off, but there are strict time limits in that regard. So any attempt by the judge not to deal with the matter should be strongly resisted. And I think a firm nod to the fact that it's obviously been serious enough for the police to have arrested this individual is often a good reminder to the court that it shouldn't try and just simply adjourn the matter to another day, which actually usually means that by the time it comes back to court, it can no longer be proceeded with. Barbara?
This is Baljeet here. I just wanted to thank you both. I mean, unfortunately, I didn't deal with the matter myself, and this was before. It was earlier than the last 6 months. But you know, from speaking to my colleagues, it was a case of the person was arrested for breach of the injunction and therefore brought before the court. But you know, the judge seemed to be very reluctant to deal with it there and then, because they didn't feel as though proper notice had been given to the defendant and so on and so forth, and was generally, I don't know if they're trying to bat it away or just simply thought it was overly excessive, you know, reaction. And on another one, you know, they listed directions and it just seemed to get adjourned a few times because they were always asking for more information. I think the impression was that as you were dealing with potential committal, you know, they were checking every dot and every cross on every INT just to make sure it's all on board. And again, it seemed to be more of a their concern that they could be putting someone, you know, committing someone, rather than appreciating that we were sort of acting in response to events and breaches as they were occurring, not, you know, because obviously you don't pre-plan for a defendant to breach an injunction. So thank you very much for the information.
But just to perhaps emphasize in terms of, and Elizabeth touched on that, I think it was in part 2 of the application. Obviously, there are different things that can be done under different provisions, and of course the procedure under CPR 81 is a separate procedure from what's set out under CPR 65 and what's provided for under the 2014 Act. But of course, if there has been if the person has been produced by the police because there was a power of arrest and the police had arrested him, then of course that matter can be dealt with at court. But then you have, I would say, the extra option of then considering whether to then go down the committal route under CPR 81.1. And of course, I have made the argument to judges that a breach is a breach of a court order is a breach, and one breach is potentially a contempt of court. But then that leads us back to the issue of, well, if it was only a fairly minor breach, is it really then appropriate to go down the full-blown committal route? So it's a quite a difficult judgment call, I find.
But I'd also just add to that, even in circumstances where there's been a breach of a power of arrest and the police has produced the person, the individual, at court, the judge often asks a local authority or a housing association whether they wish to proceed in terms of committal. If there is an indication that a warning, a stern warning will suffice, that's what the court would ordinarily, in my experience, give. They wouldn't necessarily then just undertake to proceed with a contempt type process. They would take on board what the desire of the local authority or the housing association would be. Are there any?
Thank you.
Welcome, Balji.
Just wanted to say, this is David from Waltham Forest. I think Fabian raised the point about the music. I don't think you shouldn't really have a power of arrest in relation to playing music because it doesn't meet the criteria for power of arrest. But the main problem with the arrest is you've got to watch out for people being arrested on a Friday, because if they get arrested on a Saturday, you can go to court on Monday. Any other day you go to court, whenever. But the problem is if you don't work on Saturdays, they've only got 24 hours to bring the guy or the defendant to court. So that's the issue. What do you do with the staff in terms of attending court on the Saturday? But if it's serious enough for that, it might be another criminal offence anyway, so the police can just arrest them for another offence. But in terms of music, they shouldn't be arresting people for playing loud music because there shouldn't be a power of arrest in the first place. You can get different powers of arrest to attach to different parts of the injunction. But the point I wanted to make was in one of our cases, we didn't actually want committal at all. We just wanted the defendant to leave the property due to, she had some real issues, but there was no point sending her to prison. So I just had to apply for committal to get a finding that she'd breached the injunction to use in a possession claim. And actually that worked, which it's the only time I've ever tried it, but it did work because a different judge then relied on the finding of breach. There was no prison involved, but the judge did make a possession order, an absolute possession order.
That's a really good point, David. That's a really good tactical way to use a contempt application, because ultimately I find more often than not, it's obtaining an antisocial behavioural injunction is only really obtained if it's truly believed that, one, it can restrain that kind of conduct. So there is a general level of understanding and compliance on the part of the defendant. But if there isn't, it's a stepping stone to ultimately obtain possession. So that really is a good tactical tip.
Yeah,
Barbara?
I agree with that, yes, yeah.
And just to touch on something that David said about there being a arrest on the Friday and what to do. I always think it's worthwhile having almost like an out office person that can be contacted in those circumstances, because it's true that the clock starts ticking. And the moment that you go beyond your 24 hours, well, then forget it. You're not going to get a judge who will deal with it. It'll just simply be thrown out. So it's always good internally to have a protocol where there is always someone who is on call for those types of incidences, I find. And lastly, just to say, you're absolutely right about noise nuisance. There shouldn't be a power of arrest attached to that kind of term, because ultimately it doesn't meet the criteria for significant risk of harm or anything else that usually is required for a power of arrest to be attached. Barbara.
Yes, no, I wanted to concur with that. Of course, in terms of a person being produced because there's been a power of arrest and a bit of noise nuisance, of course, there is always the possibility of perhaps the police having an overzealous interpretation of the terms of the injunction and perhaps missing which clauses of the injunction the power of arrest is attached to. So I think that's a very valid point to raise, and that's clearly something to be considered by the local authority once it is informed by the police that an arrest has happened. So I agree with that. We've had a very useful and stimulating discussion. I note it is nearly 11:40. Is there a final question or a final observation you want to make?
Just one more point, which is that we had a case where I think the point was raised already, but it's about just reminding the judge that they can't bat it off forever, so that there is a specific time limit in the statute, so it's worth taking that along. Because we had a case where that point was missed, I think, and it caused a real problem. So they have to deal with it. If they're going to keep the defendant in custody, it has to be listed within a certain number of days. It's all in the statute.
Well, thank you. I'm trying to move on to the last slide. I'm not sure I can do it. Elizabeth, can you move to the last slide? Yes, here we are. The last slide. Thank you very much for staying till the bitter end of this seminar, and thank you very much for making such useful comments and observations. So we found this seminar useful. Of course, when you talk about procedure, it's probably always a bit boring, or has the potential to be a bit boring. But actually, when you think about CPR 81 and the procedural safeguards that it tries to ensure are complied with, it's actually, I think, a rather interesting part of the CPR to look at and think about. So thank you for staying the course, and I'll give the final word to Elizabeth.
Thank you, Barbara. Yeah, just to reiterate, thank you for attending. Thank you for your useful questions and observations, really appreciated. If there are any other areas that you would like Lamb Chambers to deal with, Barbara and we are more than happy to give these talks, and thank you for attending.
Well, thank you very much. Goodbye.
Bye-bye.
Bye.